Hi, everyone. Good afternoon. My name is Shannon Mead. I'm the Executive Director of Littler Mendelson's Workplace Policy Institute. WPI is the government affairs public policy shop of the firm, and it is my great pleasure this afternoon to moderate this panel, the Equal Access to Justice Act Reform. And it is also my great pleasure to introduce someone who has served as a mentor and has meant so much to myself and so many of my friends and colleagues in the DC area in the world of government relations, and that is Randy Johnson. For many years, Randy ran the Labor and Employment Division and the Labor Relations Committee for the U.S. Chamber of Commerce, and he is now the chair of the Administrative Review Board at the U.S. Department of Labor, where he also previously served as a judge. He's also a beloved, I am told, immigration law professor at Syracuse and formerly also at Cornell Law School, where he was a visiting fellow. And I can go on and on and on about Randy, but all the bios are included in the books that are on your table. You can also scan the QR code. But if you read through there, you can also learn more about Randy's love of motorcycles. The commentator for this session is Michael Gray, who is the Global Co-Client Affairs Partner for Jones Day, representing corporate and private equity firms in labor and employment matters. And so with that, I'm going to turn it over to Randy.
Thanks, Shannon. Thanks, Shannon. I do want to thank Sam for keeping the temperature here to 50, so you guys can
We're trying
all
to
stay
save
away.
money because of the cutoff of the foreign students.
Well, I was going to, or the Trump grants, I don't know. This is going to be a whirlwind tour through the rule of law, the Equal Access to Justice Act, and society in general. I know we only got 15 minutes, but a lot to cover. But I'm going to take advantage of my gray hair and just say, why am I doing this on my own time, by the way? I'm not affiliated with the Department of Labor here today. They may or may not like what I'm about to say on things. But I started, my time I was with the Reagan administration at DOL, working with the Wage and Hour Administration, went up to the Hill for 10 years, went down to the Chamber for 20 years. And what I saw, which I know is obvious to all of you in this room, it doesn't get talked about enough, I don't think, and I think Mike, is the little entities in this country, they just get beat up by government. I'm sorry, there's no other way of putting it. It's true. It's true about small businesses, but it's true about individuals also, which I'm going to talk about. And even coming around the corner when I was watching TV on Sunday, there was a guy on TV who had to defend himself against the government and talking about how he had to spend like $5 million of his own savings. And he proved his innocence, but how many people have $5 million? And so people might, and I've brought this up before, and people might say, okay, everyone knows that you can't fight City Hall, Randy. Okay, that doesn't mean it's right, guys. It doesn't mean we shouldn't try and do something about it. And one of my frustrations of working on this issue since 1984 is like comprehensive immigration reform. We haven't been able to do something about it. But maybe we can, at the end of this presentation, get you guys on board. So I'm going to talk about the hollow promise of the rule of law and enforcement, how the Equal Access to Justice Act can help remedy that, or amendments there too. How many of you are familiar with the Equal Access to Justice Act? Okay, well, more of you should be.
By the way, that's more
this-
than I predicted, so.
Oh, really? Okay, well, that's, so here's some overview of the topics, because we don't have a lot of time. I'm going to read basics of each rule of law enforcement, and you're going to keep me on time, right, Shannon? And I-9 enforcement, why it's not working. I'm going to violate the one rule of lots of, well, we had the economists with their tables, so this is better than that. But this is worth reading. The Equal Access to Justice Act is one of the broadest reaching yet most obscure federal laws in existence. Obviously, this happens to be one of the most obscure. Its basic function is simple. In any case, be in court or in an administrative agency proceeding where the federal government's position is not substantially justified, a prevailing party is entitled to receive attorney's fees provided that there is no other applicable fee-shifting statute. It is a safety net designed to make sure that a party cannot be harassed by unjustifiable government activity solely because of the prohibited expense of attorney's fees and it was originally passed to protect the small business community from governmental overreach, just as an earlier fee-shifting statute. This is back in 1980. Overview, this is a recent committee report. It's in this respect an anti-bullying law. Out of the Ninth Circuit, now this is a case where a woman professor actually, Sam, was on the no-fly list, and she couldn't get her name off the no-fly list for like 5 years, even though the agency admitted it was a ministerial mistake by someone buried in the bureaucracy. They're like, well, we're still not gonna reward this woman her attorney's fees. And it took them 6 years for her to get off the no-fly list, and then she asked for attorney's fees, and she had to fight that up to the Ninth Circuit, which the Ninth Circuit said the agency, DHS, pursued scorched earth policy. In enacting EJA, Congress stated for many citizens, the cost of securing vindication of their rights and their inability to recover attorney's fees preclude resort to the adjudicatory process. When the cost of contesting a government order, for example, exceeds the amount at stake, a party has no realistic chance and no effective remedy. In these cases, it is more practical to ensure an injustice than to contest it. So, okay, we got equal access to justice out there. I don't have time to go through the debates on Capitol Hill in 1980 and 1984. Bipartisan recognition. It's very similar, Mike, that it's very similar to some of the things that are being said, an administrative state out of control. And the Equal Access to Justice Act was intended to remedy that. Now, why is that important? Let's go back to some basics in America here about the concept of the rule of law. Now, you can't swing a dead cat without seeing someone saying something about the rule of law in the Washington Post, the New York Times, whether they're a Republican or a Democrat. And they're all using it in defense of whatever they want to use it in the defense of. But there's two basic principles. One is that the government should treat its citizens fairly. And when the government doesn't treat you fairly, you should have access to some type of effective independent judicial review in order to hold abuse by the government in check. I mean, this is sort of common. You don't see it much. People use the rule of law differently nowadays. They don't use it in this fundamental way. But that's sort of the fundamental principles that no one argues about. The rule of law is a concept of universal validity. It equates a system. Well, I won't go into this. The point is, the rule of law is intended to help ensure citizens will continue to support their government. And the end of the rule of law can eventually lead to the corrosion of government. That may sound hyperbolic, but I think you have to look at sort of the bigger picture here and what could go on if we continue with the status quo. Now, this is what I use for my students up at Cornell or Syracuse. I know it's very basic for you guys. Legislation's at the top, interpretive regs, all you rulemaking lawyers make money at this. But the base is enforcement, and this is where most of America bumps up against government. It's not up here at the regs, writing NPRMs and all that stuff. And yet, this is the area that's least written about. I did a Google search. You find a lot about regs and legislation, very little about enforcement. I think that's because it's anecdotal, very hard to quantify. So one thing I did at Cornell was look at I-9 enforcement and how it affects the employer community and the small business community. And frankly, what I found was that a lot of the DHS, formerly INS, investigators were abusing small employers in the I-9 enforcement system. Now, I guarantee at Cornell there was not much paper out there in terms of analyzing the burden of government and small employers. I was like a very unpopular Republican up at Cornell. Maybe I'm somewhat more popular now, or more unpopular. And I don't have time to go through all the quotes. I interviewed practitioners, because you have to interview practitioners, because there's not stuff written on this stuff. I looked at the case law where the courts had to come in and slap the agency down, but that takes litigation, that takes cost. I've also looked at the National Labor Relations Act, same kind of result. I had many hearings going back to 1984. Shannon was still a baby. Yeah. And the same situation in the NLRA, which is small businesses simply getting beat up by the board. And it's interesting, if you look back at the original enactment of sort of the attorney's fees bills, the National Labor Relations Board was, even going back to 1980, was one of the first agencies in opposition to attorney's fees relief for small businesses.
Rand,
So-
can I stop and ask
Yeah.
just a question that in learning about the process I found so extraordinary, and I recommend everybody to read Randy's paper. But we're talking about 40-plus years of this. I think everybody in the room would probably agree access to justice, terribly important, small businesses, people without means. Why are we talking about it? Why do we have so few hands know about this statute right now?
Yeah, and I have to guess that Sam doesn't teach it. Secondly, that he should. But I
I
think
teach
word-
nearly everything. I have to give my colleagues something.
it's true. I think word has gotten out that it's so hard to recover under the Equal Access to Justice Act because you have to show that the government's position was not substantially justified, that people throw up their hands and say, not only do I have to win the case, Mike, I have to relitigate it and win it a second time to get attorney's fees. And the word is out that the agencies, and this isn't me speaking, well, it is right now, but resist paying attorney's fees under the Equal Access to Justice Act no matter what. And that's true from across the board based on practitioners. So people don't use it because they found, I'm just going to spend more of my client's money and not get relief, and then they're going to be doubly pissed off. But hopefully, and the other part is, of course, I'm sorry, it only applies to smaller entities, which are typically for employers 500 or less employees and $7 million in net worth. But it does apply to individuals who don't have that sort of net worth requirement. In that case, I mentioned to you in the Ninth Circuit, that was, like I said, one woman who brought up and eventually got recovery. Okay, so you would say, and to your point, Mike, so fortunately, the Congress reinstated a requirement by the Administrative Conference of the United States to look at how are the agencies using EJA. Now, think about all the litigation that pay the college bills for your kids. How much stuff is going out there? And so what do we have in here? At the entire Department of Homeland Security, we have 46 EJA awards that were granted. Out of the Department of Justice, two for the entire Department of Labor, 5 for the National Labor Relations Board, which was a high point. In 2021, we had 4 for labor and 0 for the board. And not only that, Mike and Shannon, what you found was if you looked at administrative conference reports, most of those were granted by the courts, which meant the agency was fought all the way to the courts, and the courts had to step in and reverse the agency. All of that cost money. Now, fortunately, there have been hearings on Capitol Hill and some of these quotes, and believe it or not, it's bipartisan support for recognizing EJA is not adequately used. Here's the American Civil Liberties Union. Although the Equal Access to Justice Act has been an important step in providing such counsel, the statute has significant limitations and has been curtailed further by court decisions narrowly interpreting the rights provided by the statute. H.R. 435 corrects these problems and thereby helps ensure that the individuals and organizations can secure their rights. Specifically, H.R. 35 would eliminate the substantial justification defense that has allowed the federal government to avoid paying legal fees to successful litigants. NFIB, small business, of course, similar sort of message. Here's you got the ACLU and the NFIB, it's on the same message. Now, some people would say, well, it's going to cost a lot, it's going to cost the government a lot of money. We can't do this because they're going to have a bunch of frivolous cases and then they'll have to pay the attorney's fees. Well, here, the American Conservative Union testified, some within the government will attempt to say this legislation costs too much. This is simply not the case. EJA, in fact, forces the federal government to cost the taxpayer less money. A reduction in frivolous federal actions will be caused when the general counsel of the initiating agency is forced to weigh the likelihood of success against the defendant's cost of their own operating budget. Same considerations everyone else filing suit must face. An NLRA practitioner, basically, so I had hearings on this back in 1984, 1985, bringing in the small business community, and the kind of stories these guys would tell, and most of them were guys back then, in terms of their inability to defend against the NLRB because they were so outmatched with the resources, backed up by the unions, by the way. Nothing wrong with that, I'm just stating as fact. And they would just say, Senator Enzi, I know I have these rights under EJA, but we get the spiel about how much it would cost and our chances of winning, we just throw our hands up and we just pay the cost, even if we've won, and walk away. And it's really worth going back. And they're all in my papers, by the way, which I know you've all read. But they're worth reading on the train on the way back. So what's a path forward? A one-pager? Okay, look. And we had a government reform panel. Where's Craig Lane? We had a government reform panel before. Are we really going to reform government? Are we going to sort of correct the tendency of some enforcement agencies to go over the top? Probably not, maybe. And are we going to get the courts to act more quickly? Because remember, it's costs and delays. We're probably not going to get the courts to act more quickly. So I would argue we should go in at the front end and say, look, let's have the agencies be more careful about the cases they bring, particularly against small businesses, so that those small businesses, the businesses who are on the marginal line with questionable cases, don't have to expend all this money to defend what it turns out to be they win, but then they can't get their attorney's fees under EJA. But if we amend EJA to provide essentially that a small business or small entity, I keep saying small business, but it's small entities, if they win, they get their attorney's fees automatically paid for. I'm oversimplifying. There's some other issues under EJA, such as the cap on attorney's fees, which is $125, which I tell Roger King, we're not going to be popular on Capitol Hill if we say we're not paying lawyers enough. So that's a problem. But I know 125 is low for most of you in this room. There are other issues with EJA. Substantial justification, much litigated, gone to the Supreme Court like 3 times, is the major hurdle. If we eliminated that, an agency would have to say, let's think twice before we bring the massive resources of government against a smaller person. Now, yes, I've heard from other sides that say that will chill enforcement, it'll shut down agencies. No, in this limited time of resources, and we know what's going on with this administration, it will make the agency be more careful about how they allocate the resources, and they will allocate them to the most meritorious cases rather than waste them on frivolous cases. So that's my pitch on that, and we can open up for questions and discussion.
Yep.
Or do you have some questions to?
I do. You're the expert. I'm just the commentator. So what would be the next step, Randy, to try to move this forward? You've got something
Right.
that's been out here for a bit. It obviously has incredible limitations, otherwise it would be used more. But what would be the next steps?
Well, hopefully it would be, one of the problems with Congress, of course, we have many committees. The bill is jurisdictionally within judiciary. Judiciary has lots of other priorities right now. Of course, immigration is one of them. However, since this is an employment law conference, one way we could do, and in fact I did, is amend the National Labor Relations Act directly to make clear that the Equal Access to Justice Act substantial justification defense would be eliminated for cases brought under the NLRA. In fact, we had a bill that, in fact, passed the House in 1985 that did exactly that. It was by one vote, incredibly, vociferously opposed by the AFL-CIO, who claimed it would chill and shut down the NLRB. I just think that was hyperbole, but it was enough that we could only get it through by one vote. So, I mean, in those hearings I mentioned, those were in front of the Judiciary Committee, and you saw the panoply of people who testified. But we could do, since it's an employment law conference, we could do narrower changes just for the NLRA or even under perhaps EEOC.
And do you think we could find bipartisan support? That's something we don't talk very often about these days, but is it possible with its sort of appeal to access for individual small entities, small businesses, that we could find bipartisan, and maybe there would be
I think we could, and one of the difficulties has been, it does only apply to it applies to companies with 500 or less employees and smaller entities, but when it comes to the Hill, often you're relying on, let me put it this way, there's been pressure to raise the threshold of the cap to say from 500 to 1,000, and therefore make the coalition bigger to push the bill. That's an option. I would argue that we would tend to lose the argument of the small businesses getting beat up by business the further up we raise it. But by definition, the coalition is limited by the size of the entities covered, and that's been a political issue.
Jen, did you?
Yep. Any other questions for Randy, Michael? Yes, please.
Suzanne Campbell, U.S. Department of Labor, opinions of my own.
As are mine.
Yes.
Yeah, okay.
As you probably know, there are other exceptions in EJA, in particular for OSHA for violations that cause a death. With the proposal, get rid of that as well, because obviously there are competing pressures on the agency. When you've got a death, you want to bring a case, and if you lose that case, you're going to have to
Well, I would say the bill it's interesting, the bill we had in the House, before it went to the floor, we took OSHA out because it was it made us too vulnerable on the House floor. So we just limited it to the NLRA. So, sure, we could do that. I think you're implying that there's an exception now for cases that are brought for death? Okay, I wasn't, for OSHA under EJA.
Oh, well, anything. But
Oh, for anything, yeah.
But OSHA and MSHA are the statutes that come to my mind to
Yeah.
write laws.
Yeah, presumably hopefully the agency, yes, I know the harm is bad, but you still want to show causation that the bad employer was the reason for that. Interesting point, though, yeah.
I think there was another question out there in the back, Shane.
Any other
Rear,
questions?
please
Yes, in
identify
the very
yourself.
back.
Jeff Rogoff, Department of Labor, not speaking on behalf of the agency.
Of course.
Fortunately, I have used the Department of Labor. It's not gotten a lot of EJA actions, but I will say, as we think about it, we ask people to do an EJA analysis before cases.
Could you take the mic?
Oh, he's got it.
No, it's not working.
We ask people to do an EJA analysis specifically. So,
Yes, it is working.
and that may go a long way to hopefully the actions initially being okay. But I think one of the things that, when you said what made me think of, is it reminded me of our duty to reevaluate when a case goes along, because we could learn something in the course of discovery, which causes our initial impressions and the way we analyze the case to change. And in government, we have an obligation to make sure that we are continually looking at facts and to reevaluate where we are. So I think a lot of what you said certainly goes to that continuing obligation to reevaluate. And I just wanted to note
No, I
that.
think that's a very good point. If I could raise a broader philosophical point, which I have with my staff, which is it the role of government to prosecute, or is it the role of government to find the truth? And I think at some point, the government becomes so invested in the case, and particularly when the solicitor kicks in, that they become more of a prosecutor. And even if the facts kind of change, and I have spent 4 tours at DOL, by the way, we're gonna win the case, damn it, versus reevaluating it along the lines you're talking about. I think that's a great idea.
You'd agree, though, it's quite encouraging, right? If they're doing the EJA analysis, then irrespective of whether or not we're seeing a lot of actions, at least it's having the impact on the agency itself.
And if you took out substantial justification defense, I bet you'd really look at the analysis a little tougher. Particularly if you took it out of your budget.
Any other questions for Randy or Michael? All right,
Even Mike.
gentlemen, thank you.
Thank you very much.
Thank you very much.